Hi, everybody. Welcome back to our next installment on the Supreme Court and the Bill of Rights. What we're going to do is we're going to start with a quick little review from our last video where we looked at the introduction to the Supreme Court and the First Amendment rights. But today we're going to start with a little building off of that point, and we're going to use those skills to look at even more cases and even more content today. So we looked at the First Amendment. And the First Amendment protects what are sometimes called the five freedoms, the five most important things to the United States when we talk about individual liberties being protected, or the five most core principles of our democracy. We have the freedom of religion, the freedom of speech, freedom of press, freedom to assemble, and freedom to petition. We have these rights, but there are limits to these rights. Understand that no right is absolute. Remember, the right to swing my arms stops where your nose begins. I can do what I want as long as I'm not taking away your rights. Once that happens, my rights are no longer protected. We looked at a couple different cases about how that's seen in the government, how that's seen in the lives of individuals. And when it comes down to the Supreme Court cases, probably the biggest misconception that so many people have is about what the Supreme Court actually does. They do not decide punishment. They do not decide what is going to happen in terms of the lengths of services, the death penalty, anything like that. What the Supreme Court decides is they decide whether actions and or laws are constitutional or unconstitutional. That is what they decide, and they use the Constitution as that basis. Is it in line with the Constitution, or does it violate anyone's constitutional rights? And that is the most important pillar we use today. Remember, that is the crux of our argumentation, and we're going to really think about the implications possibly of this decision, right? Stare decisis, let the decision stand. Where will this impact us in the future? So really think about the big picture when you argue, but make sure you come down through the lens of, does this take away anyone's constitutional rights? Was anybody's constitutional rights violated? And that should be the answer to your argumentation and your rationale. So we're going to start with the Second Amendment today. We'll pick up where we left off. We're going to do the Second, Third, and Fourth today. The Second Amendment says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. You cannot take away the right of the people to keep and bear arms, but the question is for what purpose? This is probably where the Second Amendment gets misquoted or misused in many different cases, right? To have a fighting force of citizens in order to prevent the government from, if they turn bad, from taking all of the supplies to be able to fight back is necessary, and that right cannot be infringed. You have to be able to fight back against the government. This comes from the American Revolution, where, remember, individuals were literally fighting against their government, the British government, and because of this, they found it necessary in order to be able to procure arms to fight back if the government went bad again, went tyrannical again. Now, what does that mean today? There's many different questions and interpretations for all laws. For example, does that mean that there should be limits on what weapons an individual should be able to have? Should they be able to have assault rifles? Should they be able to have tanks? Should they be able to have airstrike drones, just like the government has in order to fight back against them? It's a very, very debated loophole today. Most people are in agreement that yes, owning a tank and an airstrike drone is illegal. However, the debate on what type of firearms are allowed for civilian use is still heavily, heavily debated today. So really understanding that all of these amendments, the Second Amendment and the Third Amendment, are not things that we typically see Supreme Court cases on in any sense. However, right, it's still even the debate or the interpretation of really what some of these amendments means are still things that we are debating over 200 years later. The Third Amendment, no soldier shall, in times of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So during peacetime, the government cannot force soldiers into your home. without your consent. You cannot be forced to house or quarter soldiers. This goes back to the American Revolution. Remember, these are the people that fought through this American Revolution. The American Revolutionary War are making this brand new government. So it makes sense why all of these amendments have traces back to that time. You can, however, in a time of war, actually have the government house soldiers for you if it is prescribed by law. It is a legal, lawful act. Just because there's a war going on doesn't mean that they can force soldiers into your home. However, right? However, if there is a legal precedent, they can do that without your consent. So, in most cases, we really see this precedent that there may be a time where this is necessary. However, right? However, there is always a limit on every single law of both the government and the individual. Our topic today is really going to focus around the Fourth Amendment. The Fourth Amendment is going to be the scope that we look at all of these court cases today for. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So this one is longer than the second and third, obviously. But we really need to break down what it says here. The right of the people to be secure in their persons, houses, papers, and effects. So people have the right to stuff. You have the right to personal property. And you are protected. You should be secure in your personal property against unreasonable, right? That's the phrase there, unreasonable searches and seizures. So the government cannot go through your private property without good reason. They cannot search your private property, and they cannot seize or take away your private property unless there is something called a warrant that is issued. If the police or the federal government doesn't have a warrant, they do not have the right to search your personal property without good reason. Right? And we look at legal precedents in this case. Now, how do you get a warrant? Is a warrant really easy to get? Can it just be, I'm going to search all of their stuff whenever I want? No, it has to be specific. You must go to a judge. You must present evidence that you believe that this individual houses this criminal action, that you have a good reason to search this, and you need a body of evidence. And that judge, under oath, must confirm or even deny what warrant should be issued to people, and officers are denied warrants many times. And so it takes evidence in order to procure this. You have to have a good reason to go through it, not just a hunch. You need evidence, and you must describe exactly what you're searching for and where you will be searching. It's not a general search of your home. So all of these things are protecting the individual. The First Amendment, right? The 5 freedoms: religion, speech, press, assembly, petition. The Second Amendment, your right to bear arms against the government if they go bad. Third Amendment, the right of the individual to protect them from being forced to quarter or house soldiers. And the Fourth Amendment, the protection of your personal property against unreasonable searches and seizures. All of these things, the repression of these rights rather, happened under the British government in the New World. And these are things that the Founding Fathers really tried to create a system that prevented these things from happening. And they put it in print in the first couple amendments to our Constitution. We are going to start with our first court case, Mapp v. Ohio in 1961. So my students, you can take out your worksheet now of the court cases and read through your rulings and respond to them. On May 23rd, 1957, 3 Cleveland police officers wanted to search the home of Dollery Mapp, who they believed to be harboring a bombing suspect along with having illegal betting equipment. They came to her door. Mapp did not allow the police to enter, stating that they didn't have a warrant and so they couldn't come in, as you can see on this cartoon over on the right. And a few hours later, the police returned, forced their way into the house, waving a piece of paper. They didn't really explain what that piece of paper was. They didn't show it to her. They just waved the piece of paper. They claimed that this paper that they had in their hand was a search warrant, but they didn't allow Mapp to inspect it. They did not show it to her. And so a kind of little scuffle ensued. She grabbed away this piece of paper and shoved it down her dress, and she tried to prevent the police officers from taking it back so she could examine it. The police officers struggled with her, and they finally took it away from her and handcuffed her for being belligerent and for kind of resisting. And so they begin to search the home. They didn't find the suspect. They didn't find any of the bedding equipment, but they did find a trunk in the basement containing pornographic material, which at the time violated the Ohio law. And so the police then go through the house. They find this material, although it's not what they were looking for, and they bring it up to court. Now, the problem is, right, she had something that was illegal. She had that pornographic material that violated the Ohio law. So should that evidence that was discovered during a search and seizure without a valid search warrant be allowed in court? So she did commit a crime, but the evidence was obtained illegally. So should this be allowed into court? What do you think? So you can stop now. You can analyze this evidence and figure out what's going on. You can pause this video right now because she was taken to court. She was charged with the pornography charge, but should her charge be vacated? Should that evidence be permissible in court if it was obtained without a valid search warrant? What is your decision? Make your decision now. At the original trial, the court found Mapp guilty and sentenced her to jail, even though they didn't have evidence of a legal search warrant to obtain that information. She appealed to the Ohio Supreme Court, and she lost again. But she didn't stop. You have this right to continue to appeal. She appealed all the way up to the U.S. Supreme Court, and she appealed to the Supreme Court on the basis that her First Amendment rights were violated. Her First Amendment right of freedom of expression was violated by this pornography law in Ohio. And she also said her Fourth Amendment right was violated by an illegal search and seizure. So what will the court decide? They will rule in favor of Miss Mapp. They rule in a 6-3 decision in favor of her that this was a violation of her Fourth Amendment rights. We hold that all of this evidence obtained by searches and seizures in violation of the Constitution is by that same authority inadmissible in a state court. We call this the exclusionatory rule, which means that this must be excluded from the decision. Because it was obtained illegally, it cannot be introduced in court. So the evidence was thrown out, and because they had no evidence of wrongdoing, because it could not be added into the court system as evidence, her charge and jail time was then vacated. Now, they take away the First Amendment right claim. They don't even ignore it, but on the 6-3 decision, they rule in favor of Miss Mapp, and this becomes a landmark decision. So moving forward, if any evidence is obtained illegally based on the exclusionary rule, it must be thrown out of court and it cannot be used as evidence. It cannot even be considered. Therefore, this becomes a huge landmark decision moving forward. We're now going to take ourselves from Ohio down to Florida. So in 2006, an anonymous, unverified tip was given to the Miami Police Department. It indicated that a man, Jardines, was growing marijuana in his house. At this time, understand that marijuana growth and marijuana possession is illegal. Now, there are some states that allow it currently, but in 2006, this was 100% illegal. About a month afterwards, in December of 2006, two detectives went to this home at 7 a.m. They watched the home for 15 minutes. There were no vehicles in the driveway. All of the blinds were closed, and there was no observable activity whatsoever. So this is actually a picture of the house much later, but there were no vehicles here. All of the windows that you see on this house, right, completely pulled down, so there was no kind of anything you could observe to indicate that anybody was home. after 15 minutes, a dog handler, a canine unit, arrived with a drug detection dog. The handler walked up the driveway to the front door on a leash, and they brought the dog up to the front door. The dog started to sniff and bark and alerted to the smell that there was contraband in this house. After the dog started barking, the handler brought the dog back to the detective's car, and he told the detectives that the dog had given a positive alert for the odor of narcotics. The detectives went up to the door themselves for the very first time after being told this, and they too smelt marijuana. The detectives then left the house. They applied for a search warrant, which was issued by a judge. They did a search, they conducted it, and they confirmed that marijuana was actually being grown inside this house. Now, the defendant, Jardines, was arrested. The big issue in this court case, the major central question that you have to decide upon, did the police violate Jardines' Fourth Amendment rights because the search warrant was obtained after the dog sniffed his property? Does the dog sniff count as an illegal search? So we have to start thinking about how this law can be applied in future years. Does sending this police dog to the front door, does that count as a search of that property or not? If it does, then this search occurred before a search warrant was issued. Therefore, all of the information based on the exclusatory rule are thus inadmissible in court. However, if it was allowed, then Jardines would face this crime. So what do you think should happen? Make your decision now. The ruling in this case, according to the Supreme Court, is yes, Jardines' rights were violated by that dog sniff. The use of a police-trained detection dog, right, whose whole purpose is to sniff for narcotics on the front porch of a private home is considered a search. And therefore, because that search happened before a search warrant was obtained, then as a result, that's an illegal search and seizure. Now, this was a very, very close court case. If you notice right here, it's a 5-4 decision. One person decided this that could have swung it the other way. But because of this, even a police dog search prior to obtaining a warrant, even though they didn't go inside the house, they only stood on the front porch, was considered an illegal search and seizure. Therefore, all of this evidence is then thrown out and inadmissible in this court case. And so he could not be charged with this crime, right, at this time, not forever, but he could not be charged with this crime with this evidence. It was thrown out of court. It's an illegal search and seizure. Therefore, right, we have to be very certain when police officers are making searches that information is not just obtained, but obtained in a legal, correct way. Because his rights were violated, this action is null and void, it is thrown out, and therefore could not be used in court. Let's move on to a new court case, Kentucky v. King. So in this court case, there's a couple different individuals involved, but I'm going to try to make sure it's as clear as possible. There was a man who was selling drugs, and police officers knew this, so they set up a sting operation, an undercover operation. This man sold cocaine to an undercover police officer. Once the police officer identified himself, the man started to flee and run away. In an attempt to get away, he ran into a large apartment complex. The police officers were after him, and he runs into a large breezeway. A breezeway is something like this. It's kind of like a giant open hallway, and each way, right, throughout this, there are doors on either side that you can go into the apartment. He gets away from the police for a short period of time. They see him run into the apartment complex, but they lose sight of him. All they hear is that he ducked inside of a door, right? Because they hear an apartment door slam. But the problem is there are so many doors, they have no idea where exactly he went. So they don't know the exact apartment that this man went into, and they have to continue to search. Now, as they go throughout the hallways, attempting to see if they can find anything that would indicate where this man went, they start smelling marijuana in the hallway. They go to the door of another individual who's completely unconnected. They originally believe it to be this man who was selling drugs to them, but they don't know where he is. Instead, they stumble across the door of a man by the name of Holy's King. Now, they knocked on King's door. They announced themselves as the police. Please open up. They didn't get any verbal answer. However, as they stood at the door, they started to hear somebody rustling around in there and things getting knocked over, and it sounded like someone was attempting to destroy evidence. So, what the police officers decide to do is they bust into that apartment and they don't have a warrant. The question is, are the police violating this man's constitutional rights by busting into the door at this moment? Time to make your decision. Think about constitutionality, think about precedent, and think about maybe what you know outside of this. Try to think as best you can and make an argument. In a landslide 8-1 decision, the Supreme Court rules that no, King's rights were not violated, and this may be extremely surprising to many of you. Now, you may have said that they conducted a search. They didn't have a warrant. They weren't even looking for this guy. They had no reason to enter his apartment before they stumbled across it. And you say this has to be an illegal search and seizure. The argument was that a warrantless search and seizure can be conducted in what they describe as urgent circumstances. And it doesn't violate the Fourth Amendment as long as the police don't create the urgent situation themselves. So, because of the situation, it's not like they started to harass someone and that all of a sudden that person starts to fight back. And so, as a result, they start going through their materials or they don't kick down the door and try to enter that apartment initially. The reason is that there was an action taking place that a crime could have been being committed, and based on their information, they needed to take immediate action. So if some police officer shows up to a door and they hear somebody kind of being physically assaulted on the other side, they can't say, "Hey, can you guys open up?" And they say no, and everybody goes home. They can enter that door to protect that individual. They heard evidence, something being destroyed, illegal activity going on, so they had the right to enter that home in order to prevent that crime from being committed. Again, these set legal precedents. So we start thinking about not only what is being done, but the context in which this action is taking place. It's super important. But we're beginning to develop a larger skill, a deeper, ability to analyze. We are now going to look at our last court case of the day, and this takes place on March 17th, 1980, in New Jersey. Two Piscataway Township high school freshmen were caught smoking cigarettes in the school bathroom, and a teacher walks in and catches them. The teacher took the two girls to the principal's office, and they met with the assistant principal one-on-one. He questioned each of them about violating a school rule by smoking in the bathroom. The first girl came in, she admitted to smoking and said she was so sorry, she was upset. The second girl, however, denied she'd smoked in the bathroom. She said she'd never even smoked in her entire life. And this girl, because she was a minor, her name wasn't released. They just used her initials, TLO. So that is where the name comes from. TLO is the name of the student. The vice principal then asks this student, TLO, into her purse to look. He demands that she hands it over. There's a little bit of not really a physical scuffle, but a verbal disagreement and a little bit of tugging back and forth. And the vice principal takes the purse, opens up the purse, and he finds a carton of cigarettes. He removes the cigarettes and he takes them out. And when he does that, he sees a package of rolling paper used for marijuana. He then, once he finds this evidence that there could possibly be more illicit drugs or other things besides cigarettes inside this purse, he then begins to take a more methodical search. He opens up the rest of the purse, empties out the contents. He finds a small amount of marijuana, a pipe, empty plastic baggies, a large quantity of money and $1 bills, and an index card of a list of names that students owed her money, and 2 different letters inside of her purse that implicated that she was selling and dealing drugs to other students. The principal then called the police and the girl's mother. The girl's mother came in, voluntarily drove her daughter to the police station. The question is, did the school violate this girl's Fourth Amendment rights? Are these schools acting as kind of parents when they're there and looking out for their interest? Or were these rights not violated? Was this an illegal search and seizure? What is your decision? The Supreme Court's ruling? No, TLO's rights were not violated. The Supreme Court ruled in a 6-3 decision that the school has the full duty to maintain a safe school environment, that they have the duty to maintain and protect their students and the student body when they're at school. And the school had reasonable suspicion to do the search, so no, her rights were not violated. So remember here, folks, it's not necessarily just the action takes place, but all of the context surrounding the incident that leads into these rulings. It's a very complex scenario to deal with. The Supreme Court lawyers have to think about so much, including the precedents this sets for the future. And really, when it comes down to these decisions, it requires a deep intellectual thought. And that's why the judicial branch is so important to our democracy moving forward, and really has been for its entirety of its existence. When it comes down to it, we looked at 3 amendments today. We looked at the Second Amendment, the right to bear arms, right? If the government turns bad, we need to have the right of citizens to raise a militia to fight back. There's different interpretations of that. The right from freedom of quartering soldiers in your home. And lastly, protection against unreasonable searches and seizures. And so all 3 of these pieces, again, further show the protection of individual rights, individual liberties, and these traces back to the American Revolution. If you have any questions on the content in today's video, feel free to drop a comment down in the section below, and I will get back to you as soon as possible. Take care, people.